Welcome back to It's Your Law, and we've got Mark back. Mark, it's unusual, I think, that you and Ray, being competitors and both being highly respected criminal lawyers that would like to have the better cases, one of you or the other of you. How did you end up being a tag team in this case?
It's an interesting story. The state had called and had indicated that they had some difficulties finding an attorney for Brendan, and asked if I would represent Brendan in Manitowoc County, and I had asked if I could get some assistance, have a co-counsel, and they indicated that they would provide certain amount of funds for that. I could pick whoever I wanted to be co-counsel. So I contacted Ray and told him about the case and that I'm willing to take it and the state said they're willing to give me some money for co-counsel if he wants to help out. And he had said, well, let me think about it and I'll get back to you. I think literally 30 minutes later, the news stations got wind of it and were at my office with cameras and asked if I'd go on camera, and I said sure. So I go on camera, and they asked if I'm representing Brendan Dassey, and I said, yeah, myself and Ray Edelstein are representing Brendan Dassey. So Ray was now stuck. He couldn't try to weasel out now.
Well, obviously you work very well together. You respect each other's abilities, and I know the court respects both of you greatly. How did you divide the responsibility during the trial?
We actually, beforehand, what the decision was that Ray would focus on much of the confession. In our case, it was a little different than Stephen Avery. We had to come up with a theory of defense that kind of focused on this confession. So our theory of defense that kind of permeates throughout the entire voir dire, opening, questions of the officers and witnesses in closing, was essentially that Brendan didn't do this, Stephen Avery did it, and that his confession shouldn't be believed. It was suggested to him by the police. And so Ray's focus was on a number of, there were 4 or 5 different either tape recorded or videotaped confessions or statements, I think it's better to refer to them as. And so Ray focused on that, focused on how the questions were asked, and then my focus was on the other side of the case, the scientific evidence, dealing with some of the cross-examination of the state's witnesses, and dealing also with our client and our expert, the doctor that we hired.
And then you divided the final argument as well?
Correct. It was nice. The judge allowed us to divide it up as long as we didn't try to rehash what the other one had brought up. So in closing, we focused, if you watch the closing, it was exactly the same way as we had set apart our separate duties. Ray focused entirely on the confession. I focused entirely on the lack of evidence that tied Brendan to the murder. And
when the jury then retired to deliberate, how many charges were they considering?
Boy, I believe it was 4 counts, 4 different charges, 4 or 3. It was 3 different charges. There was a possibility of a lesser included. I think that was offered as the 4th.
Okay, so they were out and they deliberated for how long?
About 5 hours, a little under 5 hours, I believe.
So you gave them something to think about in what appeared, at least from the outside, as being almost an impossible case.
As the case went on, it appeared as if we had I think we had a very good jury. They listened, they seemed to be very attentive. I think we lost them at the point that the state put on the videotape statement of our client talking to the police. It was about that point that the jury went from nodding their head, listening, that ping pong effect of witness and question, and you really understand that the jury is watching you. At that point, they stopped that. They watched the witnesses or looked down. They didn't give us a lot of eye contact after the videotape.
And so he's found guilty,
yeah.
And eventually there was a sentencing. And what was the result of that?
Well, there was a pre-sentence recommended that he should obtain some parole eligibility, some release date for extended supervision. And the state asked for, I believe 50 years. The family, I think, was asking for 75 years or no eligibility, and the judge ordered 41 years eligibility.
Now, throughout the handling of this case, especially while the Steve Avery case was pre-trial and trial. Certainly the prosecutors were wanting to negotiate with you, and if you could get your client to turn on Steve, they were offering some kind of a so-called bargain. Am I correct?
They did once, while the Stephen Avery case was either being tried or prepared, and we had several discussions after Avery's case, and even during our trial, they would approach us and discuss with us some possible resolution.
And am I correct, when that happens, you simply make a record that you have told your client about the option, and your client makes the decision? Whether or not it's consistent with your recommendation, the client has the final decision-making power.
Absolutely. We always give our opinion, but I think consistently, especially in this case, we would give our opinion, but also make sure that Brendan knew it's your call. And with all clients and all defendants, that's the best way to deal with it, is to obviously give them an opinion, because that's why you're hired or that's why you're appointed, is to provide counsel. But at the same time, make sure they're aware that they make the decision.
We've only got a minute left. What options does Brendan have left?
Well, Brendan has direct appeal to the Court of Appeals and potentially Supreme Court. They could file a request for a new trial. Potentially, it's very slim, but potentially after that, the appeals are more habeas type actions, either in the state or federal courts.
So that now a new group of lawyers will be appointed for him, because he is indeed at this moment in prison and indigent and eligible for some form of public defender?
I believe the State Public Defender's Office has appointed him an appellate attorney to review this.
And the appellate attorney searches the record for error, am I correct, to try to persuade the appellate court that an error was made, his constitutional rights were somehow violated or overlooked, so he didn't get a fair trial, and he deserves a fair trial, of course, like we all do. If they can convince the court, he may be back in front of another jury at another time.
Whether it was an error by the judge, an error by law enforcement, or an error by counsel, that's what they're looking for.
So I know what it's like. You prepare for a case for a half a year or longer. You don't go on family meetings and family movies, and you cancel things, and often people have told me that they leave a year of their lives in the courtroom with every trial. I always thought that was a stretch, because it's kind of fun. But besides being fun, it's exhausting. And then when it's all over, your client is found guilty, yet you have the satisfaction of knowing you performed a very important service, not only to Brendan Dassey, but to the system.
You know, I agree. We spent literally 12-hour days during this trial. We were in Madison hotels, Manitowoc hotels. We were away from our families for weeks. But I can say honestly, when I was driving home that last day, at least I felt proud that we did, I thought, the best we could do. And I still think I wish I could be a fly on the wall in the jury room, because I'm sure they had to be thinking about something.
I was following you in a half-dozen newspapers, and I wanted to say that both you and Ray made me proud to be a lawyer, because you're doing what we really are supposed to be doing.
Well, I appreciate that. Thank you, George.
Congratulations. And we'll be right back. Well, I hope you appreciate the inside view of the Brendan Dassey trial. It's not a perfect system, as Mark says, but it's the best one that's been devised so far. To work, it requires two things at a minimum. It requires dedicated professionals like Ray and Mark, who believe in the Constitution, the presumption of innocence, and their professional responsibility of following the preferences of their client. The other side is that it requires people who are willing to serve as jurors. And that's a service that many people want to duck. It's every bit as essential as being a lawyer. Even if you're not a lawyer, you're going to get a chance to be a juror. It's a privilege, and it's a critical, important cog in democracy. That's my opinion. I'm George Curtis.